That's how you got to take it in. So if that hadn't occurred, we still wouldn't be seeing you. Yeah, there really isn't a need to answer that, but you wouldn't have come in on your own because you said you didn't know how to, even though you had attorneys.
Right out of the gate, Judge Simpson sets the tone, and it's firm. This isn't small talk. This is accountability. The judge is essentially saying, you didn't come here voluntarily. You're here because circumstances forced you here. That matters. In bond hearings and bench warrant situations, intent is everything. Courts look at whether someone took responsibility on their own or whether they had to be dragged back into the system. And notice how the judge points out that the defendant had attorneys but still didn't know how to come in. That's a red flag. When someone is represented and still fails to appear, judges see that as either avoidance or indifference. And in the courtroom, indifference can cost you your freedom. This opening exchange frames the entire hearing. Credibility is on trial just as much as the charges. The judge isn't just listening to excuses, he's evaluating patterns. And when someone only reappears because of a traffic stop or an arrest, that tells the court something powerful about compliance. The real question for viewers, if you knew there was a warrant out for you, would you voluntarily walk into court or wait until you were forced to? Because in this courtroom, that difference changes everything.
Terrence, can you...
Assistant Public Defender J. Dollinger on behalf of Mr. Gangard. Your Honor, I'm just going to hold the door open.
Okay.
Mr. Gangard, can you please state your name for the record?
Terrence Michael D. Allen Ginyard.
And Your Honor, we're here for PCC today as well as the Community Corrections warrant. And I just want to first start off with the PCC. I am still working as fast as possible. I've talked to Mr. Cook about this case. He was just assigned to it after Mr. Overwater. So I am working to get a resolution as quick as possible on this. So I would be asking for adjournment for 2 weeks.
I'll adjourn the probable cause conference to 22nd,
As
2025, 9 a.m.
26, Your
The
Honor.
bond violation.
As to the bond violation, Your Honor, I did send into the court some a urinalysis as well as a lab that was taken for blood that goes back 2 weeks in response to the allegations that he was testing positive.
Where do you have that? Where do I get the indication that this test goes back 2 weeks?
May I approach, Your Honor?
Yeah.
Okay. All right.
What I'm going to do, record to reflect a bench conference in this case. Right now he has a no bond bench warrant because of 2 tests. I've received other information that quite frankly isn't inconsistent with the testing because it could be low. His testing could indicate low or no use within the past 2 weeks. I will adjourn this matter out, send it to the 22nd. I'll adjourn it out 1 week to the 15th, 2026 at 9 a.m. At this point, however, the defendant's bond is revoked. I will indicate that.
This is a major turning point. Bond revoked. That means the defendant is no longer trusted to remain free under previous conditions. When Judge Simpson says he has a no bond bench warrant because of 2 tests, he's referencing positive alcohol testing, likely through SoberLink. 2 positives, including a retest? That's serious. Now here's the nuance. The defense presented lab results suggesting low or no use within 2 weeks. That's strategic. They're trying to create doubt about whether the positive tests truly reflect recent alcohol consumption. But the judge points out something important. Those results are not inconsistent with the earlier positives. Translation: the lab report doesn't erase what already happened. However, did you catch that line? The only reason I may consider release is because of the advocacy of your counsel. That's huge. Judges rarely say that out loud. It tells us the attorney is doing effective damage control behind the scenes. This moment shows how fragile bond status can be. 1 or 2 failed tests can shift the entire dynamic, and it raises a question: should courts lean toward strict enforcement, or give room for contested science and testing discrepancies. Because here, freedom is literally hanging on interpretation.
Based upon the request from counsel, once I can get a straight story on this, then I will consider at that time his release on a scram tether as opposed to the sober. But at this time, defendant.
Right.
Letting you know that.
Your Honor, can I speak 1 second? I'll make it quick. So on here, I don't think what you did see, I know it says that the CDT result 1.4 is consistent with low or no alcohol. But at the top, it says my current result and flag is 1.0, which means it's under the 1.4, which could be low or none. So my test is 1.0. Okay.
He did read it.
All right. That's all, sir. That's all I want.
And I also know, so that the record is clear, that on the sober link, on 2 occasions, you tested positive. And on the retest, continued to test positive.
Understood. That's why I pay for this test, though.
I understand why you did it.
Yes.
But I'm telling you how this looks.
Understood.
All right.
Yep.
And the only reason I may consider release is because of the advocacy of your counsel. Because normally I wouldn't consider release. Normally what I would do is I just revoke your bond and you're going to sit there.
Yes, sir.
But I'll bring you back in a week and we'll look at it again.
Yes, sir.
Thank you.
All right. Thank you.
Thank you, Your Honor.
I just
got it.
Let them go back. Okay.
You said
I put it out instead of 2 weeks. I put it out what? To the 15th. Yeah, it's a Thursday, the 15th.
At what time?
Well, I set it all at 9. It'll go into a block. You can talk to his attorney. They'll figure it out. Okay.
Thank you.
You're welcome. Your name, sir?
Davion Lamar Gavin.
Thank you.
And Your Honor, we do have an agreement to waive Mr. Gavin's preliminary examination with an agreement to felony FIDA at circuit court.
So he's waiving.
Yes, Your Honor, and I'm having him execute the form now, and I have reviewed the relevant rights with him.
Sir, you're waiving your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right. Examination having been waived, defendants bound over to circuit court. Single count.
Thank you, Your Honor. We acknowledge the state of the information, waive formal reading, and stand mute.
Defendant having waived formal reading, standing mute. The court will enter a not guilty plea. Pretrial will be set for January 21st, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor. Mr. Gavin would like me to address bond.
Go ahead.
Thank you, Your Honor. So Mr. Gavin indicates to me that his previous failure to appear, he had attempted to be present on Zoom, but didn't hear that his name was called. He does tell me that he would have stable housing, thing with a friend in Detroit. We would have no objection to a home confinement tether. Additionally, Mr. Gavin has let me know that he has 2 jobs that he would be working if he's released, one at Motor Casino, one at McDonald's. He does tell me his life is significantly more stable than when he failed to appear.
But he failed to appear in 2024.
Correct, Your Honor.
And this is 2026.
It is, Your Honor.
Okay. So what was he doing for now approaching 2 years?
I was working. Like after they issued the bench warrant, I didn't know how to go about that. And so I started working at McDonald's right after. And
Okay, so how'd you end up back in custody?
when we was driving, we was driving, and he got
whenever a story starts that way, it's not going to be good. Go ahead.
No, he got pulled over because they was doing like 90, and he didn't have his license, and his car insurance was suspended. And I was going to get him, and when I pulled in, they was letting him go, and then they asked for my ID. And when I gave them my ID, and they said I had an arrest warrant, and
That's how you got to take it in. So if that hadn't occurred, we still wouldn't be seeing you.
This explanation did not help him. When someone begins a story with "me and my friend were driving 90 miles an hour," that's not usually heading towards sympathy. And Judge Simpson immediately reacts. If the story starts that way, it's not going to be good. That's courtroom intuition. The defendant admits he didn't know how to clear the warrant, even though he had attorneys. Then he casually describes being pulled over because his friend was speeding and uninsured. That's not proactive compliance. That's accidental accountability. Judges evaluate failure to appear cases through one lens: responsibility. This warrant was issued in 2024. It's now 2026, 2 years. The judge's question, what was he doing for now approaching 2 years? Cuts to the core. Time matters. Delay signals avoidance. And here's the critical line from the judge. So if that hadn't occurred, we still wouldn't be seeing you. That's devastating. It reframes the arrest not as bad luck, but as the only reason the defendant is back in court. Let's pause here. Do you think someone who didn't turn themselves in for 2 years deserves bond reduction? Or does that gap automatically undermine trust? In bond decisions, trust is currency. And right now, his balance looks low.
Yeah, there really isn't a need to answer that, but you wouldn't have come in on your own because you said you didn't know how to, even though you had attorneys. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Thank you.
Your Honor, we're requesting that Mr. Myers be released on a PR bond with a tether to his grandmother's house. I'm sorry, to his mother's
My
house.
mother's in the courtroom too.
She has a lot of health needs, and she has.
Is this the same motion that I already denied?
We've never done a motion.
Oh, yes, you did. The motion on this, a motion to modify his bond, which I denied on December 11th. But go ahead.
Is that enough? She's in the courtroom?
Yeah. He wants to let you know again that his mother is present today. She has a lot of health issues, including her vision is severely impaired. And Mr. Myers is her support system. He takes care of the house. He helps his mother get to and from her medical appointments. He has a strong tie to the community. He has a positive support system, which includes 3 of his family members are here today. And
You went to school with her.
he also states that you went to school with his mother as well.
Pardon?
You went to school with my mother.
I did?
You seen me in 2008, and you said you did know my mother. She's right there, the light-skinned lady.
The light-skinned lady? Really? Which one do you want me to pick out?
The one that's laughing right there.
Okay.
Her right there.
Hello. Okay.
Okay. Your Honor, we believe tethering him to the house would keep him from interacting with the complaining witness, and he is well aware of the PPO and this court's direction to have no contact with the complaining witness.
You know I don't play with him either. I don't play with you either. You know that.
What?
No, I don't give you no hard time either. I do what you do.
People can give me a hard time. When you go back, you can ask that young lady. Is there a response from the people?
Your Honor, since this motion was already brought about a month ago, he asked the court to be denying it and just highlight the facts where the defendant is reported to have come to the victim's house, threatening to kill someone if he sees there. Also showing up at the victim's church, creating where he also.
That's a lie.
Safety of public is necessary. And that bond should be continued.
I ain't threatening nobody.
All right. I've already heard the motion and ruled. I don't hear anything different. If maybe there's a conversation had with the prosecutor and there are certain conditions that will alleviate their concerns, then maybe the parties can stipulate to something, but I'm not at this point going to change the bond or the court's decision. The motion for bond reduction is denied.
This second bond argument, this time for Mr. Myers, adds emotional layers. His mother is present. Health issues, community ties, family support in the courtroom. These are classic mitigation arguments. Defense attorneys highlight stability, caretaking responsibilities, and tether proposals to show reduced risk. But the prosecution counters with something far heavier. Allegations of threatening behavior toward the victim, showing up at their house, even appearing at their church. Wait, that changes everything. Bond decisions are not sympathy contests, they're safety evaluations. And when there are claims of threats or intimidation, judges become extremely cautious. Judge Simpson makes it clear, unless there's something materially different from the last motion, he won't reconsider. He even hints at negotiation. If conditions can alleviate concerns, the parties can stipulate. That's judicial diplomacy. But without agreement, he won't override prior rulings. This moment shows how Bond hinges on public safety, not personal hardship. And here's the tough question. Should caretaking duties ever outweigh alleged threats to a victim? Courts often have to balance compassion against protection.
Thank you, Your Honor.
Today's hearing highlights the central tension in pretrial justice: freedom versus accountability. In the first matter, Bond was revoked due to positive testing and unresolved contradictions in alcohol monitoring. Even with lab reports suggesting low or no recent use, prior positives carried more weight. Judge Simpson left a narrow opening: future reconsideration based on clearer evidence. But for now, detention stands. In the second case, involving failure to appear, the 2-year delay proved decisive. The judge viewed the return to court as incidental, not voluntary. That undermined trust and led to denial of bond reduction. In the third matter, despite strong family support and health-related arguments, allegations of threatening conduct prevented modification of bond. Safety concerns outweighed stability claims. Across all 3 decisions, one principle dominated: credibility. Judges rely heavily on patterns of behavior when deciding pretrial release. Audit compliance history often matters more than promises. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.